You wanna shoot someone to one of the. The witness has expired. That certificate is next.
Any other witnesses to be examined?
The first time, we'll just go through.
You are representing whom? He is present?
Present.
Prosecutor so-and-so present. Accused Panchayat Dakhar present. Summon issued to the witness Joel Pathu. Return with the report. That the witness expired on 14 September 2017. Copy of the registered death certificate. Issued by competent authority is placed before this court. Death certificate is taken on record and marked as paper mark 1. The witness is declared dead. Prosecution shall take steps to summon further witnesses. Refix for evidence.
And
in this case, we have not taken steps. And last date is course only.
Accused Mithu Mahali present along with defense counsel. M. Lamare, prosecutor so-and-so present. Prosecution shall take steps to summon witnesses. Refix for evidence.
None of the accused is absent despite giving the date. Not this case, I pray for one more day.
Why?
Not really. I'm prepared, but it's not completed yet. Come on, dead man. Positively.
What is this case?
This case, attempt to murder. It's all right.
How many witnesses are there?
9 witnesses.
What is the case, prosecution?
Allegation was he hit his wife with a dowel. Allegation was he assaulted his wife, his own wife with a dowel.
The eyewitness?
Seems to be an eyewitness.
So what is your argument? Why?
Handled by J.C. Korea.
There are 3 witnesses.
No, 9 witnesses.
Please read the evidence of the wife.
I stated I know of the case. I am the complainant and also the victim in this case. I cannot recollect the date, month, year of the incident, but the incident took place 6 years back. On the day of incident, I was all alone watching clothes at a place called Marban, Mokanyang Kreterchi. There were also kids around. Suddenly, my ex-husband Shri Ramthwa, the accuser, came from behind and struck me with a dowel thrice on my head. When I was first hit for the first time, I do not know who was the person behind me, but when I was hit for the second time, I turned back and saw that it was the accused, Ram Pawar, who had assaulted me. I was bleeding profusely from my head, and though I made an attempt to run away, but I could not, and I suddenly fainted and became unconscious. When I regained back my sense in the evening time, I saw myself in the hospital along with my family member. I was admitted in Yalong Civil Hospital for 2 days and 2 nights. After I was discharged, the doctor advised me to visit Clayton CPHD for dressing my wound. Later, I launched the complaint against the accused. Exhibit 1 is the FIR. I filed against the accused. Exhibit 1 by 1 is the signature. Later, I accompanied the police to place of occurrence. I showed them the PO and the police drew the sketch mark. My statement was also recorded by the police. I also came before to give my statement before the magistrate. I state that till today my health condition is deteriorating. Since the time of the incident, I was bedridden for 9 months prior to this day.
Alright.
As such,
What is your cross examination?
cross-examination. I do not know. I do not know how to read and write, but I can put my signature. I am having a very weak eyesight, so I will not be able to see what is written in a paper. It is a fact that I have not written Exhibit 1, and I also do not know what its content are. I cannot remember if the statement made before the magistrate and the one made before the court are the same or not. It is a fact that I was admitted in the hospital for 2 days. After being discharged from the hospital, I frequently visit for my medical checkup. I can recognize my signature in Exhibit 1. I do not know if the accused person is having some other criminal case apart from the incident case. I never met the accused after the incident, and I have forgiven him. The accused and myself belong to the same village but are in different localities.
Yes. Wednesday.
Sorry. I will inform Jessica.
Please, prosecution come prepared.
Yes, yes.
Next Wednesday we take it up. This matter.
This Wednesday, next.
Next.
I'll inform Jessica in a second.
We'll not adjourn.
Okay.
This matter is fixed for final argument. The defense counsel prays for time. Accused is absent without any steps. Issue non-bailable warrant against the accused and notice to the bailer. This matter will be taken up for final argument on the next date fixed positively. We fix for hearing.
Lost it up.
Judgment will be. Okay, we'll see this matter. Closer up, we'll see. Maybe we deliver Wednesday, this coming Wednesday.
So, King India.
No, this death certificate has not been produced till date. It can be fixed on another date.
Accused died.
Yes.
The prosecution prays for time to produce the death certificate of the accused. The prosecution is at liberty to take assistance of the IO to produce the death certificate
This
of the accused.
may not be listed as and when I get it, no, produce it.
No, we cannot keep it updated.
Okay.
Yes.
Monroe Spotlight.
Yes. How many applications you have filed?
Only one,
2 applications, one has been disposed of.
and this is the application on the section 311 CRPC
For
recalling a witness.
What is
I
your-
filed my show cause.
you filed.
It's taken a file, but there's a copy with me. I file,
You filed. You received the copy?
The written information was given by PW12 to the police. So, Your Honor, the evidence of PW12 has already been recorded by the state. However,
When was the evidence recorded?
I was
8 August 2022. Which show cause,
8 August 2022.
He was cross-examined on the same day?
Yes.
Yes.
Your Honor, the FIR filed by this People 12 was not exhibited at that time, and it was not relied by the prosecution at that time. So that is why, Your Honor, I've come to this court at this stage, at a final hearing stage, while an issue came up before this court, because here the police has investigated the second FIR, that means the subsequent FIR, and charge sheeted on that basis only. So, Your Honor, kindly come to the order dated 16 July 2025.
Yes.
Learned Defense Counsel submits that he heavily relies on the argument that the investigation in the case was initiated based on the second FIR file. Learned Defense Counsel further submits that the investigation on the second FIR is not permissible and the question is no more res integra. However, a very vital document, that is the information dated 3/2011, given by the headman to the officer in charge of Amlaran PS, on on record. On examination of the exhibits exhibited during trial,
Was not brought on record during trial. And the said document, the defense argued that it is the first FIR.
yes, yes,
Yes.
on examination of the exhibits exhibited during trial, this court finds that the information given by the headman on 23/2011 in writing to the officer in charge of Amaram PS was not brought on record as an exhibit. As such, it will be very difficult for this court to look on any documents which has not been brought on the docket of the court during trial. So, Your Honor, my submission is that Viruta, being the headman of the village, was the one who prepared and signed the FIR, written FIR. And Your Honor, I've chose People 12 for to recall People 12 because to prove the genuineness of the documents as well as his signature also. Your
There are
Honor,
two FIRs in this case.
yes,
The first FIR was not exhibited.
no,
Has he made any whisper about filing of the first FIR in the His evidence?
it came during the cross-examination of the IO.
Let's look at the evidence of that.
Blue 15.
PW 15. Paragraph.
Comes with cross-examination dated 3rd July 2023. I received information about the incident on 23/2011. The accused person was arrested on 23/2011. On being shown Exhibit 4 FIR, the information was received on 21/3/2011 at 9:15 a.m. It is a fact that I have arrested the accused person before the receipt of the FIR. I have arrested the accused person before receipt of the FIR Exhibit 4 because I have received information from the headman of Thangli village. On receipt of the information, I have entered in the GD entry number 425 dated 23/2011. I have received information from the headman of Thangli village in writing. It is a fact that I did not register the written information received from the headman of Thangli village.
Where was the FIR filed in this case?
First
The FIR
FIR
which concluded into charge sheet.
21 March 2011.
The FIR was filed on 21/3/2011.
by PW5.
Hmm.
And the first FIR was filed on 23/2011 by PW12.
PW5. And the first FIR on
23/2011, 20th March
by
2011,
PW
12.
12. So the investigation was carried out based on the FIR filed by PW5.
5. And the accused person was arrested on 20th March 2011 based on the first FIR. And the first FIR has been registered as GD entry also.
But never investigated.
No.
Yes. One second. Where have you stated this in your application under 313? That the first FIR was filed on 23/2011 by PW.
Para 2,
Please read.
that the applicant states that the instant case has been taken up for final argument, and one of the issues which came up during the hearing, that there were two
Yes,
FIRs
yes,
regarding this.
yes. Where have you stated that the investigation was carried out based on the FIR filed by PW5?
Same paragraph was registered,
Yes,
investigated.
yes.
No, why this application deserves to be dismissed? At the very outset, the defense were given chance to cross-examine witness. They have never brought under anything from the witness to say whether the FIR was lodged by him or not. If this and even that fact, copy was duly supplied to them. They had a fair chance to brought it to the witness at that point of time. I have made up in my show cause in para 9, that the accused failure to exercise his right to cross-examine the witness on certain points does not entitle him to selectively exercise his rights at will. Furthermore, the FIR has been supplied to the accused since the stage of...
1 minute. Para 9 is the prosecution respectfully submit that the accused attempt to bring the said documents on record.
No, that is the other application.
This has been disposed of.
Yes.
Para 9. Yes. The accused failure to exercise his right of cross-examination the witness does not entitle him to right further. The FIR has been supplied. Now, this copy of the first FIR was supplied.
Yes. Since
Along with the charge sheet.
yes, so you had fair chance to access the document. It's not that we have hidden the document or not supplied it to them. They had fair chance. They could have taken due care of that and brought it to the witness at that point of time. Now at the belated stage, when this honorable court is just about to decide the matter on merits, they have brought this fact.
Do you have any decision to rely on that at this stage we can summon on this ground?
No, I have one decision, which is 2019 6 SEC to
Yes. What's this?
03.
What is this?
In this case, Your Honor,
What is the relevant paragraph?
para 8.
Yes. Please read.
Here they have discussed the length or duration of the case is not issue to recall the witness. Para 8. Having given thoughtful consideration to the rival's submissions and having examined record with reference to law applicable, we find it difficult to approve the orders impugned It appears just and proper that the application move in this matter under Section 311 CRPC be allowed with direction to the trial court to ensure that the testimony of the doctor conducting first postmortem comes on record. uh, Section para 10. It needs hardly any emphasis to that the discretionary powers like those under Section 311 are essentially intended to ensure that every necessary and appropriate measure is taken by the court to keep the record straight and to clear any ambiguity insofar as the evidence is concerned, so as also to ensure that no prejudice is caused to anyone. The principle underlying under Section 311 CRPC and amplitude of the powers of the court thereunder have been explained by this court in several decisions. In Natasha Singh versus CBI, though the application for examination of witnesses was filed by the accused, but under principles relating to exercise of powers under Section 1, this court observed inter alia as under. Section 311 CRPC empowers the court to summon a material witness or to examine a person present at any stage of any inquiry or trial or any other proceedings under CRPC, or to summon any person as a witness or to recall and re-examine any person who has already been examined if his evidence appears to it to be essential to the arrival of the decision of the case. Undoubtedly, CRPC has conferred very wide discretionary power on the court in this respect, but such discretionary discretion is to be exercised judicially and not arbitrarily. The power of the court in this context is very wide and is in the exercise of the same it may summon any witnesses as a witness at any stage of the trial or other proceedings. The court is competent to exercise such power even suo motu if no application has been filed by either of the parties. However, the court must satisfy itself that it was in fact essential to examine such a witness or to recall him for further examination in order to arrive at a just decision of the case. Para 11. The indisputable fact situation of the case remained that the daughter of the appellant died on an unattended on so in
Okay,
Nigeria.
that's the facts.
Yes, fact.
You know, I think if I'm not mistaken, I've supplied one copy which I'm relying on. This is a state of entity versus Kumar Yadav and another. On last date, if I'm not mistaken, I've given. This is 2016 to SC. State of entity, state and city of Delhi versus Shiv Kumar Yadav. Anyway, if it's not there, I'll supply it. I'll just read
What
the
is it?
relevant paragraph. It is further well settled that fairness of trial has to be seen not only from the point of view of the accused, but also from the point of view of the victim and society. In the name of fair trial, the system cannot be held at ransom. The accused is entitled to be represented by a counsel of his choice, to be provided all relevant documents, to cross-examine the evidence. So this is my case. I've already supplied the documents. It's not that I have hidden the document. The object of provision for recall is to reserve the power with the court to prevent any injustice in the conduct of trial in the stage. The power available to the court is to prevent injustice and to be exercised only if court, for valid reasons, feel that injustice is caused to the party. I'll give this paragraph to you. This application is filed. Need to improve the case at a belated stage. Whereas Honorable Court is about to deliver its verdict.
That's all? That's all? The petitioner, the accused. The accused has filed a petition number 103/25 dated 31/7/2025 under section 311 inter alia praying for recalling the witness PW12 for cross-examination. Full stop. It is pertinent to mention that this application has been filed at the stage of final argument. The prosecution has filed show cause to the application. Stop. The petitioner submits that the learned counsel for the accused submits that there are two FIRs in the instant case. The first FIR was filed on 23/2011 by PW12, and the second FIR was filed on 21/3/2011 by PW5. Full stop. The investigation was initiated based on the first FIR, based on the FIR dated 21/3/2011 filed by PW5. 21/3/2011 filed by PW5, which concluded in a charge sheet under section 302 IPC. The contention of the accused is that the second FIR, the contention of the accused is that investigation carried out in the second FIR, investigation carried out based on the second FIR is not a lawful investigation. However, in order to drive home the argument that there is two FIR, both the FIR needs to be brought on record. To stop. Comma. Inadvertently, the first FIR filed by PW12 on 23/2011 was not brought on record during trial. The learned counsel for the accused submits that for the just decision of the case, re-examination of PW12 is indispensable inasmuch as through PW12 the second FIR, the purported second FIR can be brought on record. A learned counsel, in order to buttress his argument, has placed reliance on Manju Devi. They placed reliance on Manju Devi versus State of Rajasthan, 2019-6 SCC 203, relevant paragraph 10 is reproduced. Paragraph 8 and 10 is reproduced. Relevant prosecutor, Shri So-and-so, strongly objects to the prayer of the accused and submits that the accused has failed to exercise his right to cross-examine the witness, and at this stage the defense cannot be allowed to improve his case. The prosecutor submits that copy of the purported first FIR were supplied to the accused at the stage of supplying copies under section 207 of CRPC. The prosecutor further submits that in a fair trial, a balance has to be struck between the prosecution and the defense. The accused is entitled to appoint a counsel of his choice and lead evidence if the accused has failed to effectively cross-examine or bring materials on record during trial. He cannot be allowed to cure the defects by resorting to section 311 of CRPC. The prosecutor, in support of his argument, has placed reliance in state bracket NCT of Delhi versus Shiv Kumar Yadav. Relevant paragraph is paragraph 11, which is reproduced. That upon hearing the tribal council and an examination of the record, this court finds that CRPC. This court finds that CRPC. This court finds that power under section 311 of CRPC has to be exercised and is a discretionary power, and it has to be exercised on the touchstone of fair and just decision. The prosecution does not dispute that the copy of the purported second FIR filed by PW12 or first FIR filed by PW12 was supplied to the accused person. At the stage of supplying copies under section 207. The question of the case being investigated based on the second FIR is a question of law and has a serious implication in the instant proceeding. Touching upon just decision of the court. It is true that under the guise of fair trial, the defense cannot be allowed to improve its case. And nevertheless, improve its case, and nevertheless, for the purpose of arriving at a fair decision, all relevant materials should be placed before the court. The FIR, the alleged FIR dated 2011 purported to be filed by PW12 is a relevant piece of document and if brought on record will have bearing on the decision of this court. Full stop. The decision relied by the defense to object to the prayer of the prosecution, Shiv Kumar Yadav Supra, has categorically observed that the object of the section 311 is to reserve the power with the court to prevent any injustice in the conduct of the trial at any stage. and this power can be exercised at any stage. It is reiterated as held by the Honorable Supreme Court in Manju Devi Supra. That the power has to be exercised that the power of recalling the witnesses has to be exercised if his evidence appears to the court that it is essential to the arrival of a just decision of the case. The question of the case being investigated based on the second FIR is a seminal question which will have a serious bearing in the case. And if the accused is deprived of leading evidence by way of cross-examination, it would cause serious prejudice to the accused. Further, it shall also deprive the court from arriving at a just decision. This court finds that re-examination of the witness PW 11 or 12 is necessary for the just decision of the court. Petition number the court for the reason discussed above. Petition number 103/2025 dated 31/7/2025 stands allowed and
Your
disposed
Honor,
of.
as this court has already allowed just one, because the witness is also from the same village of the accused, so at least a condition may be imposed, you know. A high chance of influence will be there.
You re-examine, you examine. When he comes, if you talk, we can't pass any order not to influence.
That's taken care of.
If we re-examine, you can examine him again. All right. Disposed of. Issue summon to the witness PW 12. Fix for re-examination of the. Fix for re-cross-examination of PW 12.
Obliged.
Halim.
Why is this Lalita Kumari here?
The registration of
that,
FIR.
Huh?
we argue regarding those two FIRs.
Initially, we had an argument, so he brought Lalita Kumar. Why the FIR was not registered at the first place? In CD, it clearly reflects that the
No. But that is 2011's case, huh?
Yes,
Amit Shah's case.
yes.
That there cannot be second
Amit Shah
FIR.
relied on.
he has already relied that also.
Yes,
We'll see.
yes.
Yes, next.
Basla.
It's for opportunity, Your Honor.
Your Honor, the accused person informed me that there is a bereavement in the family, Your Honor. Could not come in.
Prosecutor Sri D. Langbang present. The Defense Counsel Srimati M. Suchiam present.
State Defense Counsel, Your Honor.
State Defense Counsel present. And apprise the court that there is a bereavement in the family of the accused. As such, the accused could not appear before this court. Refix for 313.
Good day, Your Honor.
Rolandson, Chairman.
Give me the charge sheet. Not committed this case.
No, committed. Your Honor.
Committed
That last date was fixed.
on the
No.
on the 30th.
Come to the FIR. Here. Yeah, please read the FIR.
Should I read it? Okay. High officer in charge, Women Police Station, Jawai. Subject, first information report. Madam, katkum kate kapang balakadaw hanan. Ngiwan ban pentip yepi ba ka beni chila na kashnong kondong tuber kabachong kabasa halat tilbo Jawai. Laklat no ha Jawai Civil Hospital Yalong menta kastep Pratrik September 2008 na kadaw baka la sya bom sya tet au ukurim jongka ubasyak khot ki Ronald Chermang bosong ubasa hami mentudu lom Chermang kene kejingjia kene kejing cha syok jongka kalajia ha kastep live waiterik August 2025 ha yingsa jongki hi alat bo jawai aden kene lepenkit yeka cha civil hospital yelong ha ka later September arjar arposan banyo jing sumar enre laklat no menta ka step pratrik September arjar arposan hakapor arbje am. And the FIR is being filed
Have
by
you received a copy of the charge sheet?
yes.
How many witnesses the prosecution is relying?
The independent witnesses only two.
Total witnesses how many?
Total witnesses
7, Your Honor,
7,
including the IO.
including the IO.
Yeah. Now, which is the witness which says that
This Chris Pulchla, 60,
PW2.
yes.
who is she?
PW2. She's the auntie of the deceased.
In her statement under 161?
Yes.
So who is the complainant?
Is this
Kishla.
Vicky Chila,
Who is she?
PW1.
PW1, he is the
Cousin.
Where is the statement? This is of no? Ricky Shilla is the complainant.
Yes.
He is the daughter. He is the son of Grace.
Yes.
Yes.
Have you received a copy of the Graceful under 164?
No.
No, not here. You know?
Page 161. From where you saying that this man, when he came back home, he saw his wife in a very compromising situation?
See this, I'll just read this PW, not PW, disgraceful, okay? Uh, on being examined, stated that I am the maternal auntie of the late Benishla. Her mother expired in the year 2023. Your Honor, I will read the relevance point.
No, read the whole thing.
Okay, and then so in that after her mother expired, she stayed in a rented house at Midmantudu village. So in that same year, she met her husband, Tri Roland Sharma. So she used to call us in the middle of the night to come and pick her up whenever she and her husband had a quarrel. So when the room adjacent to our rented house was vacant, we called her to stay here. So during her stay near us, she left her children, one girl 4 years old and son who is 1 year 7 months old to my care. She is an alcoholic. On the 31st August 2000 August at around 2 a.m., I heard late Banishla was coming uh, to her rented house along with one man. In the morning, I saw one man coming out of her room and was going to the latrine. So I suspected that man slept in her house. So at 7 a.m., her husband, Sri Roland Sharman, came to my house to meet the children, and I then told him that there was one man who was sleeping with his late wife, and that he should advise her since they did not listen to her. So he said that it was not an issue, but he directly went in the residence of the deceased, and I heard the thumping sound coming from her room. Soon after, her husband came and told that he asked the man who was sleeping with late Bonnie as who had given him the permission to sleep with his wife. So he gave the man 2 to 3 slaps, and the man ran away. He also told that he had slapped late Banish Chilla as well. He took the children with him. He had his son a haircut and even gave him bath. He brought the children back home
Yes.
and gave.
Yes. Yes. Yes.
You know, like my learned friend has raised before, it's on book that the deceased and one of the person were caught in a compromising situation. In my 164, it's not reflected.
You have 164?
No, no, I don't.
The bill application. Yes.
You know, 164 it states differently. If I may read out, you can hear it. I know about the incident as my niece, Srimati Boni Shisha Shala, had expired on 31st 8 2025 at around 7 a.m. in the morning. Sri Boni Shisha Shala, husband, Sri Roland Sharmang, came and knocked at my door's house at Lattlebot Juwai and asking if my niece, so and so, and her children is at home. I told him that she was inside her house. Thereafter, the accused proceeded towards the house of the victim and assaulted her. After the assault, he took one of his child, Master Ivan Mishala, for a haircut. And after the haircut, he returned his son back home and left. Later that day, we checked if Bunisha Shala is well. However, she seemed not healthy and there was wound in her face. As Srimati Punisha was very weak and she could not eat or drink, we had insisted her to eat, however, she refused. We had informed her husband so and so about the health condition of his wife, however, he informed us that he has gone outskirt for his work. For about 2 days, she remained inside her room sleeping, and on the third day, we took her to the hospital at Yalong for medical checkup, and as she was in a critical condition and in the hospital, she refused to get medical care. As she refused to get medical attention, and the doctor referred her to ICU, and on 8 9 around 2 a.m. she expired. I last saw Roland Sharmang on 8 9 2025 when Srimati Panshan was in the hospital.
Yes. Give the copy to 164 to them.
Yeah, Your Honor, in the 161 also.
Both the copies give. Both the copies of the informant. Yes.
The nature of injury, Your Honor, is very grievous. I'll take Your Honor to the medical requisition when the.
That is beside the point. We are at the bail stage.
But still, so and so, but the in 164 never said that the other person was present.
That goes more against you. Which statement is correct? 164 or 161?
But
We are at the bail stage. With this material, with these materials we are deciding bail. Now tell me, which one will rely? We are at the bail stage. These are your documents.
Yes, sir.
So tell us which one will rely. Look at the conduct of the accused. If he was a person, very irresponsible person, he will not take his children for a haircut.
You know, let the witness be someone just a complainant, just two witnesses here.
We are at the bail stage. Why should we wait for the witnesses to come? With these materials, we have to decide the bail application. We can't say that we'll defer the bail application for the purpose of trial. That is not fair.
But this matter
Now, at this stage, he's moving a bail application. These are the material before the court.
Yes, sir.
So we have to decide the bail application based on the material before the court. Either we grant or we refuse. Now, you have read the statement under 164. There is no whisper about a man coming to her house, but then she says that a man came and slept in the house.
No, assault was there.
But a man seeing his wife with another woman, what do you expect him to do? This is not a provocation. A man sees his wife with another man. This is not a provocation. Is that an assault with an intention to harm her? He has been provoked.
But as my friend has said that he only slapped her. Look at this, you know, you heard the witness said, I heard a thumping sound.
He might have slapped.
Thumping sound, you know.
He might have slapped, he might have kicked, he might have what he did, he knows. But she's also an alcoholic. He may have maybe she's an alcoholic. Look at the statement of the auntie. She said she's an alcoholic.
Even the medical report also indicates that.
There is an history from the evidence. We are not accepting. We are only for the purpose of bail. Whether there are evidence to grant him bail or not. With these evidence, whether we should grant him bail or refuse bail.
For the prosecution, I cannot say whether to grant, you know, but refuse.
But what is your objection?
My objection, you know, that the assault is very grievous, you know, which led to the death of the deceased.
Grievous may be, but look at what circumstances. If a man comes to steal in your house and while stopping him, you hurt him, grievous hurt. But can we say that you are a criminal? A man sees his wife with another man, and after that he assaults his wife. Look at the amount of provocation. And look at his conduct. He's not a man who just comes and creates troubles in the house. Thereafter, he paid some money. He went out to work. He sent his child for a haircut.
If you go 164, it seems there was a history of several assault.
Because she's alcoholic. Maybe she's into this practice. Both the statements give. How long is in jail?
But then
At the time when we filed this application,
164
one
of
had
Meghalaya
said
says so.
43 days, which is 4 months or something. Right?
Yes.
Yes, sir.
That's your it's your material, your evidence.
Yes, yes.
We have to decide bail application based on the material which is there before this court. It's a bail application. This is a bail application. The section 483 BNSS for the release of the accused Roland Sharma. The accused was arrested. When?
On the 9th.
The accused was arrested on 9/12/2025 in connection with Joy PS case number 88/9/2025 under section 103(1) of BNS 2023. The investigation has been concluded. Charge sheet has been filed. Case has been committed to this court for trial. The accused has been in custody for
143 days.
143 days. Pusto. How many days?
146 days, Your Honor.
146 days. As on today.
Yes.
As on today. Pusto. The accused had preferred a bail application before the court below. However, the learned court below was pleased to decline to entertain the bail application for an offence triable by the session court by the order dated
What order dated on the 9/12/2025.
9/12/2025. Full stop. Next paragraph. Learned counsel for the petitioner submits that the accused is the husband of the deceased. What's the name of the deceased?
Bani.
Bani Shisha.
Can you spell it?
BANY.
Bani Shisha.
Bani Shisha.
The accused found his wife along with a man in his house when he was away for his work. On seeing his wife with another man, the accused, out of anger, landed few slaps on the wife and the alleged paramount of the wife. Thereafter, the accused, thereafter, the wife was admitted in the hospital and she died. Full stop. Next para. The learned counsel has drawn attention of this court to the evidence of PW, evidence of the PW graceful Shilla and submits that to the evidence of has drawn attention of this court to the statement of PW graceful Shilla recorded under section 164. Recorded under section 161. Is it 161 or 180?
180 BNSS.
180 PNSS. And submits that the statement of the witness clearly reveals that the deceased wife was found with another man in the house by the accused. This enraged the accused and led to a physical assault. First stop. The defense submits that this is a case of provocation by the wife which led to the unfortunate incident. The defense submits that the accused had been in custody for a considerable period of time and prays that the accused may be enlarged on bail. Full stop. Next para. The prosecution objects to the grant of bail on the ground that the medical report of the victim, the post-mortem report or medical?
The medical itself, it reveals
The
actually
medical report of the victim reveals that the victim had suffered serious injuries.
even in postmortem also reflects like the intracranial damage, injury.
Had suffered serious injuries. There is a prima facie evidence to show that the accused was involved in causing the injury and death of his wife, bracket victim. As such, the victim is name of the victim. Full stop. The prosecutor submits that. Further submits that. Considering the seriousness of the offence, considering the gravity of the offence, and the stage considering the gravity of the offence and the material on record, the accused is not entitled to bail. Full stop. Next paragraph. That after hearing the rival counsel and on examination of the record, This court finds that FIR in the instant case was filed on 8/9/2025. In the FIR, it has been alleged that the accused had physically assaulted his wife on 31/8/2025. The victim wife suffered injury and she was treated. Where? Which hospital?
Civil
She was
hospital,
treated
Yellow.
at Civil Hospital, Yelong, and she succumbed to her injuries. Post op. The investigation uh, has been concluded. The case is ready for trial. The factors which needs to be taken into consideration while granting or refusing bail is the gravity of the offence, circumstances under which the offence was committed, and the chances of the accused fleeing the trial, no, evading the trial. Post op. Next one. Admittedly, the accused in the instant case is the husband of the deceased. They were living together. Along with the children at Miminturuna,
No, alat lebok.
huh?
Lat lebok.
At Latrabo. PW, the prosecution witness, Graceful Chilla, in a statement under section 161, in a statement under section 180
180 BNS.
BNSS, has disclosed that the victim was found in a company of a person, of another person, by the accused. The accused, on seeing his wife with another man, got and dragged and assaulted his wife. Full stop. The circumstances under which the accused had the accused is alleged to have inflicted the injury appears to be very provocative. No man can tolerate to see his wife with another man. Stop. There are evidence to show. There are prima facie evidence to show the involvement of the accused in causing injury. At the same time, there are evidence to show. There are prima facie evidence to show. There are prima facie evidence to manifest a provocation on the part of the wife, bracket deceased. The act of the accused with the evidence on record at this stage cannot be branded a criminal intended act for the reasons discussed above. They continue then. For the reasons discussed above. Criminal intended act, comma, for the reason discussed above. Full stop. This court has examined the material on record only for the purpose of granting bail, only for the purpose of examining the prayer for bail, without attaching any conclusion to the merit of the case. This court finds that the accused is entitled to be enlarged on bail. Accordingly, the accused, Ronald Chirmang, is enlarged on bail on the condition enlarged on bail on execution of a PR bond of rupees 20,000 with two sureties of like amount, and on the following condition. 1. The accused shall appear before this court on the date fixed and stand for trial. The accused shall not influence any witnesses or tamper with the evidence. The accused shall not leave the jurisdiction of this court without the permission of this court. Bail application stands allowed and disposed of. Yes, next.
Postpone, huh?
ICI Lombard,
No,
National Insurance.
Fixed cost.
You are for whom?
For claimant, Your Honor.
You are for whom?
Claimant, Your Honor.
No, you are for whom?
For National Insurance.
There is no national insurance.
I have plead, Your Honor.
Huh?
I already filed a petition, pleading.
The last order, Your Honor, we have been pleaded as party.
Yeah. It's fine. Okay. So you are for reclaimant.
Yes, Your Honor. I filed a implement with the national insurance. Yeah.
We have allowed, na?
Yes, Your Honor.
So
This was the steps.
we serve the copy to him.
Yes.
You have to receive the copy.
Yes.
You file it in statement.
See next day.
All right. Direct counsel for the claimant present. Direct counsel Sri A. N. Rimbai appeared for the New India Insurance Company,
National Insurance.
a national insurance company. What about this Diwan P.O. Noktudu,
That one was passed as 40 and
ICICI Lombard?
they appear on the last. They are absent today.
Absent.
None appeared for ICICI Lombard. Fixed for filing written statement by the OP,
Three.
OPs.
Billion.
We're done here.